Hey. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting in Boston within the Father Commonwealth. Draw near, give attendance, and shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning and welcome to the Appeals Court. I'm Judge Milkey. To my right is Judge Walsh. To my left is Judge Smith. And together we are your panel for the 4 cases we are hearing this morning. I want to assure the parties that we have read the briefs and the record, so we're familiar with both the arguments and the facts. And I say that because, generally speaking, 15 minutes is not a great deal of time, so we urge you, to the extent possible, to cut to the chase. That said, if you feel you have said all you have to say and you still have time on the clock, there is no shame in sitting down. As one of our former colleagues used to say, if you hit a home run, there's no reason to run the bases twice. And with that, I will call the first case of the morning, 2022 P615, Commonwealth versus Santiago.
Good morning, Honorable Justices. May it please the Court, Elizabeth Lazar for the appellant, Joey Santiago. As you know, the lower court revoked Mr. Santiago's probation after finding that he violated 2 conditions of probation. Now, the Commonwealth has conceded that there was insufficient evidence to support one of those violations, namely that Mr. Santiago failed to report to the batterer's program as required. The Commonwealth does concede...
So it has to go back in any event, correct?
That depends on whether the court agrees that the second violation was unsupported as well.
But I mean, at a minimum, you're going to get a remand. Is that?
Potentially. No. If the court, had these violations not been found, his term of probation would be ended already in March of
All probation has to show is 1 violation.
Correct. Yes.
So it doesn't need to, if we find him in violation once, it doesn't need to go back.
It does, yes, Your Honor.
Does or does not?
It does.
Okay.
And that's...
Because the case law is clear, if there are multiple grounds and one fails, then it has to go back unless the judge made it clear that he wasn't relying on the second ground.
Correct. And in this case, since he cited both violations, according to King, 96 Mass Appeals Court 703, it would go back. So Mr. Santiago argues here, though, that he cannot be held in violation for the reporting requirement. And that is because due process requires that a defendant have adequate notice of conduct that will result in revocation. And that said, probationers are entitled to reasonably specific conditions that provide clear guidelines about what will be a violation, and that's from the Lally case. Now, in this case, there were 2 pieces of evidence at the hearing regarding the reporting requirement. The first was found in Exhibit 2, which is in the record appendix at 31, and that's the conditions of probation that Mr. Santiago signed. And it states, report to your probation officer at such times and places as he or she requires. And Mr. Santiago signed that paper. Now, the probation officer further testified that Mr. Santiago was required to report every 2 weeks. He did not testify, nor was there any evidence that Mr. Santiago was made aware of when his probation officer was requiring him to report. Now, the probation officer that testified did not meet with him to go over these conditions. So it's not as though he explained them to him and said he had to come every 2 weeks. There's nothing in evidence.
The probation officer did say that, I believe it was a she, correct?
The testifying officer?
Yes.
Oh, it was a man.
Man, okay. Yeah. That he or someone tried to contact your client and could not get through at the phone number that your client had given. How does that factor in?
Your Honor, the probation officer made that statement during closing argument. It was not put into evidence. And so the defendant didn't have a chance to cross-examine the officer on that point. That was all given in the closing argument, where the judge, I believe 4 times, told the probation officer, please constrain your closing argument to what's in evidence. And there were multiple statements like that that were not put into evidence. And so probation actually had 2 opportunities to present evidence. When their case in chief and the court asked if they were done and probation rested. After the defense put on the case, probation was given another opportunity to put in any evidence or any materials that they felt the court would need, and probation rested. And so those statements, unfortunately, were not in evidence that he had given the wrong number, and that allegation should not be considered by the court. So
Is your client still incarcerated on this charge?
he is on parole, but he was sentenced to 18 months
Okay, but he's out now.
on parole.
Okay.
So the Commonwealth argues that Mr. Santiago had to contact the probation officer to ascertain the reporting requirement. Now, this is not a reasonably clear condition of his probation. It's not in the conditions, and there was no evidence that he was directed to do so. And as King states, a defendant cannot be found in violation of a condition that would have made sense or might have been intended, only those that are unambiguous. And so here, there's no clear statement of when or how he's to report. And so any ambiguity also must be construed in favor of the defendant. And that comes from Lally and Ruiz. And I've addressed the Commonwealth's argument that he gave the wrong number. Again, that was not in evidence and was not a basis for the violation that he provided incorrect number. The Commonwealth also states that the reporting requirement was no less ambiguous than the requirement that he report to the batterer's program, but that's simply not true. In evidence was a referral to the batterer's program. It gave information about it, who to call, how to contact them. Here, there is nothing in the record to show that Mr. Santiago was given an adequate notice of what he had to do for reporting. And so to find him in violation would be a violation of his due process rights. Now, the other issue from the hearing that the Commonwealth has conceded to was the fact that the probation officer testified that Mr. Santiago did not report to the batterer's program. That was a blanket conclusory statement at the hearing. It was based on hearsay because Mr. Traveras, the probation officer, does not work for the batterer's program, and so he had to be informed of that somehow. And given the fact that that was the sole basis for finding the violation, that hearsay statement, the hearsay had to be substantially reliable. And there was no indication that it was substantially reliable. And this is also addressed in the brief, an examination of the Hartfield factors to determine substantial reliability. The judge did not undertake that analysis. Nonetheless, if he had, it would not be satisfied here because there was no information about how that information was relayed to the probation officer. So in this case, Your Honors, Mr. Santiago is requesting that the court reverse the court's order revoking his probation. Thank you.
Thank you very much. We will hear from the Commonwealth.
Good morning, Your Honor. Stacey Gauthier for the Commonwealth. The Commonwealth has conceded here that there was insufficient evidence presented that the defendant failed to participate or complete the batterer's program. We have also conceded that the judge erroneously precluded the defendant from entering two medical reports into evidence that would have gone to his ability to pay for the batterer's program that we've conceded. So the issue here is really whether there was sufficient evidence presented that the defendant failed to report to his probation, and it's the Commonwealth's position that there was, in fact, sufficient evidence presented.
Was there any evidence, actual evidence, of when and how he was supposed to report?
No, Your Honor. The only evidence that was presented was the conditions of probation form that he signed that said that he was to report to probation at such times and places as the probation officer required and to make no false statements. That was the only evidence that was presented because the person from the probation department who had, I guess, apparently explained the conditions to the defendant did not testify at the hearing. But I would suggest that that form, along with the defendant's signature on the form, and also there was a box on the form that said you must comply with these unless, they're struck by the judge. None of those, that requirement to report wasn't struck by the judge. So I would suggest that that put the defendant on notice that he was to report. The probation officer's name and phone number was right next to that requirement, so the defendant could have called the probation officer. His number was right on there. And then apparently it did come out towards the end of the hearing that the probation officer had tried to contact him at the number that he had and was unable to.
This is during the closing portion.
That's true. However, what I would point out is that there's two overriding principles in probation revocation hearings. One is that they're flexible in nature, and the second is that all reliable evidence should be considered. So I would suggest that even though it happened at the end, if the judge wanted to take that evidence at that time, he could. Again, they're flexible in nature.
I mean, there's flexible, right? And then there's violations. And I guess even if I were to consider, or we were to consider the fact that a probation officer reached out, how does that amount to a violation? In other words, probation officer could call the probationer every single day. Right? And the violation is that he didn't show up. I don't even know if the probationer can read. I don't know if English is his first language. I don't know if somebody just said in a busy courthouse, sign here, and somebody will call you later. Right? So I agree, flexible, I agree, administrative hearing, and these are not trials. And it's a low standard of proof, but...
And the probation officer is not a lawyer, I would also...
That became evident.
Yes, yes.
So
it did.
I understand all of that, and I appreciate and applaud the Commonwealth in not fighting the other two issues. So I'm interested in your position that there's enough here for us to find a violation with a conclusory statement, even if I accept that the probation officer himself attempted to contact. It's not what the probation officer did or didn't do, it's what the probationer did or didn't do.
I would just suggest that he would have had to make a good faith effort to comply with his probation conditions. In my brief, I cited to Commonwealth versus Bader al-Sod. I'm not sure if I'm pronouncing that right, but in that case, they found a violation of probation where the defendant failed to make a good faith effort to comply with his conditions. This was a gentleman who was from Saudi Arabia and had agreed to probation with conditions, but then also agreed to be deported, and then he was deported and wasn't able to report. But the court found that there were two conditions that he could comply with, even being out of the country, which was to pay the fees and to at least report his address. And he didn't make any attempt to do either, and so that they found that he was in violation. And I would contrast that with the Commonwealth versus Poirier case, also in the brief, where there was no violation found, where a defendant had attempted to be connected to a GPS, but was unable to do so. So they found, because he had made a good faith effort in that case to comply with the GPS, but was unable to, there was no violation.
I mean, probation, I suppose, in hindsight, could have alleged a violation of providing false information as far as contact.
That's correct.
Maybe you'd have a leg to stand on, right?
Yeah, we've conceded 1.5 issues, but I would suggest that at the low standard preponderance of the evidence in a probation surrender hearing, I would suggest that notice, that pre-printed notice on the form was enough, along with the probation officer's name and phone number.
I would just add, and again, it's silent, it wasn't developed in the record, but this also, as we know, was during COVID.
That's correct.
And I think that the context is that courtrooms are operating differently, courthouses were operating differently. There were orders from the administration, from the governor about court closures, things of that nature. So when you're saying we may rely on a probationer's obligation to check in with probation, I think it's a bit colored to that context as well.
Which way does that cut?
You care to offer?
I don't recall specifically. I know at one point that they didn't want, that the trial court administration didn't want people to go into the courthouse. It was for emergencies only. I didn't look into that, for this brief, and I don't know how the dates coincide, but I guess that there is a possibility that this took place at a time when they didn't want people to go actually into the office and to report.
Thank you.
Thank you. If there's no further questions, I'll rest on my brief for anything that was not addressed.
Thank you very much. I think we understand the issues.
Thank you, Your Honors.
The case is submitted. Our next case is 2022 P474, Commonwealth versus Escobar.
Good morning, Your Honors. Jennifer O'Brien for the defendant on appeal, Jamal Escobar. Before I get started, I'd just like to clarify two things for the record, if I could. One of them was an error on my part. The operating after was not count 5, it was count 6. I'm sorry, it was count 5, not 6. I think that's a little confusing in my brief. The second thing is that the defense counsel did not concede all of the misdemeanors here in the closing argument. That's something that the Commonwealth has raised. If you look at the closing argument, and that's volume 1, page 112 to 115, in the closing, with respect to the assault and battery dangerous weapon, he argues that this was an accident. It was not intentional. With the leaving the scene, he said that they knew who he was, so he didn't have to leave his name. Malicious destruction, he said there was no malice. The reckless operation, he appears to start to concede, but then he argues that he didn't almost cause an accident with anyone else on the highway. He did concede the failure to stop, but then ultimately says that asked the jurors to find the defendant not guilty of all of the charges. He said the Commonwealth was, the police officers were mad and they threw a bunch of charges at the defendant just to see what would stick. The Commonwealth has conceded one of the arguments, so that's my home run. I won't argue that. I'll walk away from that one. This was really a case where the combination of errors deprived the defendant of a fair trial. I'll start with the text messages if I can. To say that these text messages were devastating to the defense is probably an understatement. Once the judge agreed, which was the beginning of trial, that these text messages were coming in, defense counsel obviously had to argue the case a certain way. He would lose credibility, I think, with the jurors to say that this wasn't the defendant. These text messages he did object to, but he objected, he gave the wrong objection. So I don't believe that it would be preserved. If you want to find it was, that would be better for the defendant, of course. But here, what appeared to happen is they got a search warrant for the phone, they got the cell phone, they gave it to the cell phone expert, whoever that was. He presumably plugged it into a computer, and they extracted everything from the phone. That person who did the extraction of the cell phone dump, they called it, wasn't present at trial. So what they had is a police officer who was guessing how the cell phone dump came to be. There were no snapshots or screenshots of the cell phone where it came in as a picture where he would testify, this is an accurate depiction of what I saw on the cell phone. They were missing a witness, essentially.
But isn't that important in the sense that had there been an objection on the proper ground, for all we know, they could have gotten that witness and done what needed to be done to authenticate?
Well, the trial was underway, so I think if he had objected properly, unless they made a quick phone call, there was nothing in the record that there was an expert listed on their witness list. I think it would have been too late in the game to call that expert to come in and testify. I don't think there was any plan to have this expert. It was just, here are the cell phone records, and here's the text messages, and they're coming in. The judge really just agreed to it kind of right away. I mean, the defense counsel did object numerous times, but his objection again was, how do we know that this was the defendant who sent these text messages? I mean, the text messages were obviously devastating. He admitted to the crime. He really kind of admitted that he didn't care. He mentioned Detective Rigo by name in the text messages. He said he was going to lie about it. It was inappropriate for these text messages to come in, and once they came in, again, it was hard to argue that this was a misidentification case or that the defendant wasn't involved in this high-speed chase. With respect to, if I could move on, the consciousness of guilt instruction,
Can I back up for a moment?
Sure.
Because I think the text messages was a very crucial part of the Commonwealth's case.
Yes.
I understand your argument of the devastating effect of the text messages, but what's your legal argument, given the standard for authentication on appeal, that we could hook some sort of error given the fact that it wasn't objected to? So what's your best legal argument?
Well, there was no objection, and that's why I put in, the ineffective assistance of counsel argument. And I know the standards are a little bit, they're kind of the same in the state court, at least. Defense counsel has passed away, obviously, so I couldn't get an affidavit. So I think on that particular ground, especially, I think it's all clear on the record that we don't need to go to and file a motion for new trial on the ineffective assistance part, because clearly defense counsel wanted to keep these text messages out. He objected to them in the beginning of trial when they came in. There would be no tactical reason for him to give the wrong reason to get them in. So I think...
And I understand your ineffective assistance of counsel and its position without first being raised below.
Yes.
But on the standalone argument that there was error in the admission of the text messages.
That the judge shouldn't have, I know the wrong reason was given, but that the judge shouldn't have allowed them in.
Tell me what the right reason was.
The right reason for allowing them in?
The
legal...
right, yeah, so you argue that the judge should not have let them in.
Yes. An abuse of discretion, I think, is the standard for that.
Because what did the judge violate when he allowed this evidence to go forward?
Well, I think the Commonwealth has to lay the proper foundation and authenticate every piece of evidence before it is admitted, and they didn't. So, and I understand you're asking we're asking a judge to, I mean, that the judge is the gatekeeper, right? So he has to make sure that a proper foundation is laid. And defense counsel did argue that the foundation hasn't been laid. Again, he did it in the wrong way. But he was arguing to a lack of foundation more or less, that we don't know that the defendant sent these text messages. So that should have alerted the judge. I mean, it's just reading this, I mean, it's obvious that they weren't put in the right way and there was an objection. So sometimes judges do say, well, that's not the right objection, but you're right, a foundation hasn't been laid. I think that, moving on to the consciousness of guilt instruction, I mean, to me, that's just, it's common sense. First of all, the defendant didn't concede to the leaving the scene of an accident. But even if he had, the original crime is running from police. So if your crime is running from police and you commit all these other crimes to commit the first crime, to make sure that you successfully commit the first crime, there's no consciousness of guilt. I think that what's important here
Why
is the
isn't
order.
that a fact-based argument for the jury to sort out? If there are multiple reasons why the defendant is fleeing, it's for the jury to figure out, oh, is he really running for this reason or for that reason?
Well, because he was running first. Like before the police even turned on their lights, there was testimony from Sergeant Rigo that the defendant kind of looked in his rearview mirror and he saw him. And then they came after him with the lights and he took off. So I think because it was the first thing he did, there was no evidence at all that he fled because he struck Sergeant Rigo's motor vehicle. I mean, it would be to punish someone for failing to stop and apologize. And that's not what the consciousness of guilt instruction is. It's saying that he's running because he knows he did this wrong. And it kind of brings into my argument with the warrants. It made the mention of warrants, outstanding warrants, even more prejudicial because jurors could already speculate that he was running from the police because he had multiple warrants. So if there's a consciousness of guilt instruction added into that and the jurors are thinking of that, then they could have thought that, wow, not only did the police know him, they've seen him many times, had multiple interactions with him, and he has multiple warrants, but these warrants must be really bad for him to take off like that and take the police in a high-speed chase in such a dangerous fashion. So I think really the consciousness of guilt instruction not only was inappropriate, it wasn't supported by the evidence, and it didn't make sense chronologically, but it really, I think, magnified the warrants coming in, the multiple warrants coming in, which is my other argument. And again, I don't know that this would be a winner without the combination of errors here, but it was objected to that the police, had multiple interactions with him. I mean, the police could have just testified, yes, I've known him just from being a police officer. It was really overplayed here, and with the multiple warrants, we checked to see if there was warrants. Yes, there were warrants. That in and of itself, again, might not have been enough to get the defendant a new trial, but when you take that in connection with the text messages and the improper consciousness of guilt instruction, I think there's enough to get the defendant a new trial in this case. And I would note that, it was a strong case for the Commonwealth, but the defendant was not driving, a vehicle that was registered to him. They didn't arrest him on scene, and yes, we had the police officer's testimony that they knew him, they had dealt with him, and they saw him clearly. But police officers are known to lie. There are police officers who lie, and that would be obviously for a jury to consider. So it's not a case where we have, a video of the defendant committing the crime. It was a credibility issue. So while it was a strong case, because there were two officers who purportedly saw the defendant driving this motor vehicle, it wasn't completely overwhelming as some other cases are.
If the knowledge of the warrants hadn't come in, wouldn't the jury have a very skewed view of what was happening here?
Well, there are people who don't stop for the police, that take off. Yes, they could have speculated that maybe this guy has something to hide, sure. I think that it could have come in, I mean, it doesn't really matter why he failed to stop, right? That's not a defense to the crime, whether he had a warrant or didn't have a warrant. There were other ways to sanitize this, certainly, with an instruction which wasn't asked for or given. We didn't have to mention multiple warrants. It could have just been a single warrant. The judge could have gave an instruction that just because someone has a warrant doesn't mean they're guilty of anything. Again, that wasn't requested and it wasn't given. Just to have it hanging out there, I think it was very devastating to the defense. And I think there were other ways, quite frankly, that it just could have been handled. They could have stipulated, they could have argued that any of the suggestions that I put in my brief, really, just to minimize this. And again, that I don't know that that's a slam dunk for the defense in this case, but when you take that with the other errors, I think it's a combination of errors case.
I think you're mixing your sports, but.
Any further questions? Thank you.
Thank you very much. We will hear from the Commonwealth.
Good morning, Your Honors. Timothy Ferreter, Assistant District Attorney from Middlesex on behalf of the Commonwealth. And I'll start with the text messages. The text messages were clearly authenticated and properly admitted. Starting on page 73, Detective Cicerone testified, "I was able to view the contents of the cell phone. I viewed photographs, I viewed video clips, and a lot of messages back and forth from Mr. Escobar to to different people. He was asked, do you recognize what's in front of you? He said, yes. These are some of the messages that I've read. Were these taken from the C cell phone? Yes." That was clearly authentication that these were true and accurate copies of the cell phone extraction. The defendant argues that these don't look exactly like they would look on a cell phone, which is true because when police execute a warrant on a cell phone, they don't look at the cell phone itself. They use extraction software, so the date and time requirements can be met. When you flip through a cell phone, it's a little harder to comply with the warrant requirements. Going to the argument regarding...
Before we leave that, I mean, just frankly thinking about my own cell phone, it takes some time to figure out, if you look through texts, who's speaking at any time and so forth. And here, tell me if I'm wrong, the testimony was kind of presented without the context of, this is what I received, this is what I looked at, this is how I knew this. To what extent are you saying that what was before the judge would have survived an objection based on authentication, and to what extent are you saying that had an objection been raised, this officer, forget another witness, still could have provided that foundation?
Sure. So if there was an objection, I think the detective could have clarified the differences between how text messages appear on a cell phone and on a cell phone extraction. How on a cell phone you have to click on the message and hit info to get the time and date info, but the cell phone extraction brings that forward because we're having a paper exhibit and not an interactive, computer where you can.
But could this officer have testified to the extraction process, which was apparently done by somebody else?
I don't know who it was done by, and so I don't think we can assume it was done by someone else. Most police departments have extraction software, and I know a number of detectives who are capable of using it. So I don't think we can assume on this record that someone else did the extraction. From the testimony, it sounds like this detective either did it or was present for it. So without an objection, without a chance to clarify, there's nothing on this record to show that this detective wasn't either the detective or was the one who properly testified to it. So I think it's a guess that someone else did it, and without the objection, there's no chance for the Commonwealth to delve any further. And I think it's up for a defendant to object on these grounds, and if he doesn't, then I think this argument is waived, and given the testimony, there's sufficient grounds to find that these were true and accurate copies and properly authenticated. Going on to the consciousness of guilt instruction, I think that Justice Milkey hit it right where this was a factual issue for the jury. The instruction was that consciousness of guilt after the alleged crash on Mystic Ave in Somerville. There was testimony that the driving became so erratic after that crash that the police had to end the chase. And I think it was for the jury to decide whether those actions went to the consciousness of guilt of the defendant or whether he was continuing his flight that he'd already started. And I think this was a proper instruction and not abuse of discretion, where they went to the contested issue of the case, which was the state of mind of the defendant, as it went to assault and battery with a dangerous weapon and malicious destruction of property, which is where the defendant really focused his efforts in this case. So where that was the primary issue, the state of mind of the defendant, the consciousness of guilt instruction was properly given, and there's certainly no abuse of discretion. As to the prior interactions between the defendant and the police, again, this is an abuse of discretion standard, and the question isn't whether there are multiple other ways it could have been done, it's whether this particular way was an abuse of discretion, and where the familiarity between the officers and the defendant went to the identification, and where the open warrants went to the reason for the stop, and they were intertwined with the action, and the kind of the facts wouldn't have really made much sense unless that came in, and where the prior bad acts of why they knew the defendant or what the warrants for didn't come out, there was really little chance of propensity evidence being an issue in this case.
Would you grant that a better practice would have been to give a contemporaneous instruction?
I think that's really up to an experienced defense attorney, whether he wants that just to the testimony to go through quickly and not get highlighted, or he wants an instruction. So where there's not one requested, I think you should defer to the defense attorney's judgment.
And was there any reason to get before the jury the fact that there were multiple warrants, not just a warrant?
They said warrants plural. I don't think they said multiple warrants, and I don't think that was really an issue that was discussed. It was plural, but I don't think it was really emphasized as multiple, if I recall correctly. Warrants, I don't think it really makes a substantial difference. If there's no further questions, I'll rest on my brief.
Thank you very much.
Thank you.
The case is submitted. Our third case of the day is a care and protection matter involving the Department of Children and Families. It's 2022 P642. I would remind the parties that this matter is impounded. You're all old hands at this, so please refer to the parties merely by status. In this case, the son and daughter, the mother or the father.
I don't know where the other two attorneys are. They might be in the waiting room.
We will.
Spoken with them this morning, Your Honor.
I can't hear you, sir.
Oh, I apologize. I was saying I don't know where the children's counsel are. I haven't spoken with them this morning.
We're missing two attorneys.
They might just be out in the room.
Why don't we wait 5 minutes, and are they counsel for the fourth case here? Both counsel?
Two just went outside, two here.
Okay, well, let's still wait 5 minutes on the DCF matter and hear it in order if we can.
I know a lot of names. I don't know a lot of faces. So I know I've worked with both of them before, but I couldn't pick them out of a lineup.
Looks like we're one down. How about those Celtics?